The Equality and Human Rights Commission is a non-departmental public body in England and Wales. Established by the Equality Act 2006 with effect from 1 October 2007. The Commission has responsibility for the promotion and enforcement of equality and non-discrimination laws in England, Scotland and Wales. It took over the responsibilities of the Commission for Racial Equality, the Equal Opportunities Commission and the Disability Rights Commission. It also has responsibility for other aspects of equality law, age, sexual orientation and religion or belief. A national human rights institution. It seeks to promote and protect human rights in England and Wales. The EHRC has offices in Manchester, London, Glasgow and Cardiff. It is a non-departmental public body sponsored by the Government Equalities Office. Part of the Cabinet Office. It is separate from and independent from government but accountable for its use of public funds. Its commissioners are appointed by the Minister for Women and Equalities. The EHRC's functions do not extend to Northern Ireland, where there is a separate Equality Commission and a Human Rights Commission. Each and both established under the Northern Ireland Act 1998 in pursuance to the Belfast Good Friday Agreement. The current head of the EHRC is Kishwa Faulkner, Baroness Faulkner of Margraevine. The EHRC derives its powers from the Equality Act 2006, which resulted from the government white paper, Fairness for All, a new commission for equality and human rights. Section 3 states the EHRC has a general duty to work towards the development of a society where equality and rights are rooted. This is taken to mean people's ability to achieve their potential is not limited by prejudice or discrimination. There is respect for and protection of each individual's human rights. Each person has an equal opportunity to participate in society, and there is mutual respect between communities based on understanding and valuing of diversity and on shared respect for equality and human rights. Section 30 strengthens the EHRC's ability to apply for judicial review and to intervene in court proceedings, through giving explicit statutory provision for such action. Sections 31 to 2 gives the EHRC a new power to assess public authorities' compliance with their positive equality duties. It can issue compliance notices if it finds a public authority is failing in its duties. Public authorities, importantly, are bound under the Human Rights Act 1998 to act in a way compatible with the European Convention on Human Rights of the Equality Act 2006 allows the EHRC to bring judicial review proceedings under the HRA against public authorities. This is a stronger tool than usual, because the EHRC is not subject to the normal requirement of being a victim of a human rights violation. Under Section 24, the EHRC can enter into binding agreements with employers. So, for instance, it can agree that an employer will commit to equality best practice audits or avoid discriminatory practices that it may identify, in return for not investigating. It can enforce these agreements through injunctions. Previously only the Disability Rights Commission had such powers. The CRA and the EOC were more limited. For instance, the EOC used only to have the power to get injunctions against bodies with a bad track record of discrimination. Section 20 gives the EHRC the power to carry out investigations when it has a suspicion of unlawful discrimination taking place. Before, this had been limited to a requirement of reasonable suspicion, which in effect led the predecessors to be much more cautious. In legal terms, this is the difference between an irrationality test and a reasonable man test. In other words, a court could not declare an investigation unlawful unless it considered that the EHRC was carrying out an investigation where no reasonable person could have come to the same conclusion. Before, a court could declare an investigation unlawful if it thought that the proverbial man on the Clapham omnibus would not regard an employer as being a suspect discriminator. There are some complications in relation to the Human Rights Act 1998 with the EHRC's powers, if it is going to be a named investigation. Also, the line between what is in the European Convention, what is actually covered by domestic legislation, is difficult to draw. At any rate, Section 28 gives the minister the power to give authorization for a discrimination case to be fought if a domestic legislation issue has dropped away, but a purely human rights issue remains. As a successor body, the EHRC's new powers were not dramatic. Some people called for the changes to go further. For instance, to allow the EHRC to bring proceedings against employers in its own name on any issue. The American, Australian, Belgian, Canadian and New Zealand counterparts can. Although it operates at subnational level, the EHRC was in 2009 recognized as a member of the Worldwide